735. The notice of petition or order to show cause and petition together with proof of service shall be filed with the court or the clerk within 3 days. 3 days after service. 735. The notice of petition or order to show cause and petition together with proof of service shall be filed with the court or the clerk within 3 days. 743. Answer. Except in proceedings for non-payment of rent. So this is not for non-payment of rent. At any time when the petition is to be heard, the respondent or any person in possession claiming possession of the premises may answer, orally or in writing. If the answer is oral, the substance shall be recorded by the clerk, or, if the court has no clerk, by the presiding judge or justice, and maintained in the case record. If the notice of petition is served at least 8 days before the time at which it's noticed to be heard, and it so demands, the answer shall be served at least 3 days before the time in the petition is noticed to be heard, and if in writing, it shall be served within such time, whereupon any reply shall be served at least 1 day before such time. The answer may contain any legal or equitable defense or counterclaim, and the court may render affirmative judgment for the amount found due on the counterclaim. 743. This is for a lawsuit brought to recover possession of real property. It's not a non-payment. It's for a lawsuit brought to recover possession of real property. 1. Except as provided in 732 relating to non-payment of rent, the answer may be orally or in writing. 2. If the papers and demand commencing the lawsuit was served at least 8 days before the return date, the answer shall be made at least 3 days before the return date. And the answer may contain any legal or equitable defenses or counterclaims. 743. This is for a lawsuit brought to recover possession of real property. It's not a non-payment. It's not a non-payment. It's for a lawsuit brought to recover possession of real property. 1. Except as provided in 732 relating to non-payment of rent, the answer may be orally or in writing. The answer may be orally or in writing. 2. If the papers and demand commencing the lawsuit was served at least 8 days before the return date, the answer shall be made at least 3 days before the return date. And the answer may contain any legal or equitable defenses or counterclaims. 745. Trial. Where triable issues of fact are raised, they shall be tried by the court, unless at the time the petition is noticed to be heard, a party demands a trial by jury, in which case trial shall be a jury. At the time when issue is joined, the court, in its discretion, at the request of either party, and upon proof of its satisfaction by affidavit or orally, that an adjournment is necessary to enable the applicant to procure his necessary witnesses, or by consent of all the parties who appear, may adjourn the trial of the issue, but not more than 10 days, except by consent of all parties. 26. 745. Where triable issues of fact are raised, they shall be tried by the court, unless at the time the petition is noticed to be heard, a party demands a jury trial, in which case there will be a jury trial. Under certain circumstances, the court may adjourn the trial of the issue, but for not more than 10 days, except with consent of the parties. And 747, if the proceeding is founded upon an allegation of forcible entry or forcible holding out, the court may award to the successful party a fixed sum as costs not exceeding $50 in addition to the disbursements. 749, warrant. Upon rendering a final judgment for the petitioner, the court shall issue a warrant directed to the sheriff of the county or to any constable or marshal of the city in which the property or a portion thereof is situated, or if it is not situated in the city, to any constable of any town in the county, describing the property and commanding the officer to remove all persons and, except where the case is within Section 715, to put the petitioner into full possession. The officer to whom the warrant is directed and delivered shall give at least 72-hour notice, excluding any period which occurs on a Saturday, Sunday, or public holiday, in writing and in the manner prescribed in this article for the service of the notice of petition, to the person or persons to be evicted or dispossessed, and shall execute the warrant between the hours of sunrise and sunset. The issuing of the warrant for the removal of the tenant cancels the agreement under which the person removed held the premises and annuls the relationship of landlord and tenant, but nothing contained herein shall deprive the court of the power to vacate such warrant for good cause shown prior to the execution thereof. Petitioner may recover by action any sum of money which was payable at the time when the special proceeding was commenced, and the reasonable value of the use and occupation to the time when the warrant was issued, for any period of time with respect to which the agreement does not make any provisions for payment of rent. 10.749. The officer to whom a warrant is directed awarding possession shall give at least 72-hour notice in writing to the person to be evicted. 12.749. Upon rendering a final judgment for petitioner, the court shall issue a warrant eviction directed to 1. A sheriff of the county, or 2. Any marshal or constable of the city in which the property or portion is located. And if it's not situated in a city, to any constable of any town in the county. 13.749. Warrant of eviction. 1. The warrant must describe the property. 2. It must command the officer to remove all persons and, except where the case is within Section 715, to put the petitioner in full possession. 3. The issuance of the warrant cancels the agreement under which the person removed held the premises and annuls the relationship of landlord-tenant, but nothing contained herein shall deprive the court of the power to vacate the warrant. And 4. The officer to whom the warrant is directed shall execute the warrant between the hours of sunrise and sunset. 753. Stay where tenant holds over in premises occupied for dwelling purposes in the city of New York, in a proceeding to recover the possession of premises in the city of New York, occupied for dwelling purposes, other than a room or rooms in a hotel, lodging house, or rooming house, upon the grounds that the occupant is holding over and continuing in possession of the premises after the expiration of his term, and without the permission of the landlord, or in a case where a new lessee is entitled to possession without the permission of the new lessee, the court, on application of the occupant, may stay the issuance of a warrant and also stay any execution to collect the costs of the proceeding for a period not more than 6 months. 9.753. In general, in a holdover proceeding in the city of New York, the court, on application of the occupant, may stay the issuance of a warrant and also stay the execution to collect the costs of the proceeding for a period not more than 6 months. That's in New York City. 735. Upon proper proof of the existence of a condition that, in the opinion the court thinks is likely to become dangerous to his life, health, or safety, the court before which the case is pending may stay proceedings to dispossess the tenant for non-payment of the rent or any action for rent or rental value. The tenant shall not be entitled to the stay unless he shall deposit with the clerk of the court the rent then due, for which purposes of this section shall be deemed the same the tenant was liable for during the preceding month. The stay may be vacated upon 3 days' notice upon failure to deposit with the clerk of the court within 5 days after it is due during the pendency of the proceeding or action. Okay, so if the respondent doesn't deposit with the clerk of the court the rent, then after 3 days' notice for failure to deposit the money, that stay can be vacated, and that stays vacated 5 days after it's due during the pendency of the action. 208.43 Housing Parts in New York City. Summonses. The summons shall state the county division and location of the court in which the action is brought, as well as the names of the parties and the addresses of the premises, and shall comply with the provisions of NYCCCA applicable to summonses. Form of summonses. The summons in cases involving an action in housing part for the recovery of civil penalties shall be in such form as may be promulgated by the chief administrator. Where a hazardous or non-hazardous violation is alleged and the summons is personally delivered to the landlord or its registered agent within the city of New York, the defendant shall appear and answer within 10 days after service. Where a summons for a hazardous or non-hazardous violation is delivered by mail or by any other method, the defendant shall appear and answer within 20 days after proof of service is filed with the clerk of the housing part. Where the summons for a hazardous or non-hazardous violation is personally delivered to the landlord or a registered agent, the affidavit of service shall be filed with the clerk of the housing part within 5 days after personal delivery. Where the summons for a hazardous or non-hazardous violation is served by any other method, the affidavit of service shall be filed with the clerk of the housing part no later than 10 days from the date the summons is posted and mailed where such mailing is required. Where the summons for a hazardous or non-hazardous violation is served outside the city of New York, the affidavit of service shall be filed with the clerk of the housing part within 10 days after service. A penalty action for an immediate hazardous violation shall be commenced by order to show cause, returnable within 5 days or within a lesser time period in the discretion of the court. So 208.43 Housing Part, New York City. The summons, it shall state the county division and the location of the court, the names of the parties, the addresses of the premises, and it shall comply with the NYCCCA. And the form of the summons is promulgated by the chief administrator. And when they talk about service and filing of the service, if it's personally delivered to the landlord, he has to answer within 10 days. If he's not personally delivered, he has to answer within 20 days. If he's personally delivered, he has to answer within 10 days. And then the affidavit of service has to be filed within 5 days after it's personally delivered. But if he's not personally served, and if he's served by mail or any other service, he has to answer within 20 days. And then the proof of service has to be filed no later than 10 days from the date the summons is posted and mailed. And if it's served outside New York City, the affidavit of service shall be filed within 10 days after service. And penalty actions for immediately hazardous violations commenced by order to show cause and returnable within 5 days or less. So, personally delivered in New York City, answer within 10 days of service, affidavit of service filed within 5 days. If it's mailed or served any other way, answer within 20 days, affidavit of service filed no later than 10 days after the date the summons is posted. And if served outside New York City, affidavit of service filed within 10 days after service, and the penalty action for immediate hazardous violation commences by order to show cause, and the returnable date is 5 days or less.